Welcome back to the deep dive. This is where we really get into the weeds of complex source material, legal texts, scientific papers, historical documents, and pull out the key insights for you.
Making it actionable, translating that dense info.
Exactly. And today, well, we're tackling something legally fascinating, maybe even a bit philosophically tricky. Preparatory offenses.
Right. Crimes that haven't actually been, finished.
We're diving straight into the source Texas Penal Code, Chapter 15, to see how the law itself defines these incomplete crimes.
It's dense stuff, the actual statute.
It really is. So our mission, for you listening, is to figure out where exactly the state draws that line. When does just thinking about a crime or maybe planning it become a punishable act itself?
When does buying the tools cross over from just shopping?
That's the core question. The law's attempt to stop harm before it happens. Now, before we really dive in, a quick ask. If you get value from us doing this, spending the time to unpack dense stuff like statutes, please take a second right now and hit subscribe.
Yeah, it genuinely helps us keep these deep dives going. Lets the channel grow.
It really does. And don't forget, our website has all the extra bits, notes, links, the statute itself for everything we talk about today. Check it out.
Okay, so Chapter 15. These laws are fundamental because they're all about intent plus action. It's like a legal early warning system.
Right. The state's saying, we don't have to wait for the building to burn down if we catch you with the gasoline and matches at the door.
Precisely. If you have that specific intent to commit a felony and you've taken, well, a real step towards it, the danger is already there, legally speaking.
And the Texas Code breaks this down, doesn't it, into different ways this pre-crime danger can look.
It does.
Yeah.
Smartly, I think. It distinguishes three main types. First, there's the person who tries but fails. That's criminal attempt.
Okay.
Second, you've got the group planning together criminal conspiracy.
The shared plan.
And third, the person who's basically asking someone else to do the dirty work, criminal solicitation. We'll unpack each one.
All right, let's start with criminal attempt. Section 15.01. This feels like the most intuitive one for most people, the bank robbery that gets foiled.
Yeah, the classic scenario. Subsection A gives us the core definition, and the wording is very specific.
What are the key parts?
Two main things. First, you need specific intent to commit the target offense. You have to genuinely want that final crime to happen.
Not just generally messing around. You have to intend the robbery, not just intend to walk towards the bank.
Exactly. And second, the crucial part, the person has to do an act amounting to more than mere preparation that tends but fails to affect the commission of the offense intended.
Okay, more than mere preparation. That sounds like the legal battleground right there.
Oh, it absolutely is. It's where these cases live or die. What is mere preparation versus something more?
Like, if I want to commit theft and I buy gloves, a crowbar, maybe scout the location, is that enough?
Generally, no. That's usually considered preparation. Why? Because, well, each of those acts, viewed in isolation, could have a perfectly innocent explanation. You might need gloves for gardening, a crowbar for home repairs.
All right. Plausible deniability.
Exactly. The law has to draw this line somewhere to protect due process. We can't punish thoughts, even dangerous ones. The action needs to clearly show the criminal intent.
So what pushes it over the line? What makes it more than mere preparation?
It's often about proximity. How close did you actually get to doing the crime? Think about that theft example. Buying the tools, driving by the place, preparation.
Okay.
But let's say you take those tools, you go to the back door at 2 a.m., you put the crowbar to the door frame and start trying to pry it open. That act tends to affect the commission of the theft. It's no longer just thinking or getting ready. It's the beginning of the criminal act itself.
Even if the alarm goes off right then or a neighbor sees you and you run?
Yes. Even if you fail, the attempt is complete at that point, legally speaking, because you went beyond preparing and took a substantial step towards the crime, demonstrating that specific intent.
Got it. The failure is baked into the definition.
Right, and sometimes that attempt can be even more serious depending on the intended crime. That's subsection B, aggravated attempt.
How does that work?
Well, if the crime you were trying to commit could be an aggravated offense like aggravated robbery, which usually means using a deadly weapon,
Okay.
then if you had that aggravating element with you during the attempt, like you had the gun on you when you tried to force the door, the attempt itself becomes an attempt to commit the aggravated offense.
So you're punished based on the full seriousness of what you were trying to do, weapon and all.
Precisely. The law looks at the whole picture of your dangerous conduct.
Now, subsection C seems weird at first glance. It says it's no defense to attempt that you actually succeeded in committing the crime.
Yeah, that sounds counterintuitive, doesn't it? Why charge someone with attempted murder if you can prove they actually committed the murder?
Right.
Well, it's about prosecutorial flexibility. Imagine a complex case. Maybe the prosecution can easily prove you intended to kill someone and took a direct step like shooting at them, fulfilling the attempt elements.
Okay.
But maybe proving the bullet you fired was definitively the one that caused the death is complicated. Perhaps there were other factors. Proving the completed murder might be harder.
Ah, so they can charge both or fall back on the attempt charge if the main charge has issues.
Exactly. This rule ensures that just because the crime was completed, it doesn't somehow erase the attempt that definitely happened. It gives the state options to secure a conviction based on what's most provable. Usually the attempt merges into the completed crime for sentencing if both are proven, but the charge itself remains valid.
That makes a lot more sense. It's a legal safety net. Okay, let's talk punishment. Subsections D and E. What's the general rule?
The general rule, in D, is usually a bit of good news for the person who failed. The attempt is punished one category lower than the offense they were attempting.
So if you attempt a first-degree felony, you get punished as if it were a second-degree felony.
Correct. Attempt a second degree punishes a third degree, and so on. Big difference in potential prison time.
Any wrinkles in that?
Just one minor one at the bottom. If you attempt a state jail felony, the lowest felony level, it doesn't drop to a Class B misdemeanor. It drops to a Class A misdemeanor. So the categories kind of compress at the low end, but the principle holds. Failure generally means less punishment.
Generally. But subsection E carves out a major exception, right? Something specific and serious.
A very significant one, yeah. This looks like a more recent amendment, focusing specifically on the attempted capital murder of a peace officer or judge.
Okay, so trying to kill a cop or judge, what happens there?
In that specific situation, the punishment is not downgraded. The attempt itself remains a felony of the first degree, with a potential sentence of life, or 25 to 99 years.
Wow, so no break for failing in that case.
None. It shows a clear legislative decision. The act of targeting law enforcement, even unsuccessfully, is deemed so dangerous, so threatening to public order, that the penalty mirrors the completed capital crime much more closely. The usual leniency for preparatory offenses is just gone.
Okay, so we've got attempt the lone wolf who tries and fails. Now, Section 15.02, criminal conspiracy. This shifts focus, right? It's about the danger of people planning together.
Exactly. The law recognizes that a group planning a crime is often, well, inherently more dangerous, more likely to succeed than one person acting alone. The core here is the agreement.
So what does subsection A require for conspiracy?
3 main ingredients. First, again, that specific intent, the intent that a felony be committed. Second, there has to be an agreement with one or more other people that they, or one of them, will actually engage in the conduct needed for that felony.
Meeting of minds, the plan.
Yes. And third, this is key, one or more of the people involved must perform an overt act in pursuance of that agreement.
Overt act. That sounds like the more than mere preparation thing from attempt. Is it the same high bar?
Not at all. That's the critical difference. For attempt, the act needs to be really close to the final crime, that substantial step. For conspiracy, the overt act can be much, much less significant.
How minimal are we talking?
Very minimal sometimes. If 2 people agree to commit burglary, the overt act could be one of them simply buying a pair of gloves, or renting a van, or even just driving by the target house to check the locks.
So the act itself doesn't even have to be illegal.
Correct. It doesn't have to be criminal, and it doesn't need to be the last step before the crime. It just needs to be any act done by any member of the conspiracy that shows the agreement isn't just talk anymore. It shows the plan is moving forward, even slightly.
That's a much lower threshold. Makes conspiracy easier to charge, I imagine.
It does, and that's why it's such a powerful tool against organized crime. It allows intervention much earlier in the process.
But how do you prove the agreement itself? People don't usually sign contracts to commit crimes.
Right, and subsection B directly addresses that. It says the agreement may be inferred from the acts of the parties.
So circumstantial evidence is key.
Absolutely crucial. Prosecutors build conspiracy cases by showing a pattern of behavior. Person A buys the supplies, person B scouts the location, person C arranges the getaway car. They're all communicating. A jury can look at that coordinated action and reasonably infer they had an agreement to commit the crime.
You don't need a recording of them saying, okay, let's do this.
You don't. The coordinated actions speak for themselves.
And once you establish that agreement and the overt act, the charge seems pretty hard to shake. Subsection C lists things that are not defenses.
Yes, and these really show how robust the charge is. It focuses almost entirely on the individual defendant's intent and agreement. Let's look at a couple.
Okay.
Number one, it's not a defense if one of your co-conspirators isn't criminally responsible. Maybe they were underage or found legally insane.
So if I conspire with someone who can't legally be convicted, I still can be.
Yes. Your guilt depends on your intent and your agreement, not the legal status of who you agreed with.
Makes sense. What about number two? Co-conspirator acquitted.
Right. This one gets a bit technical. Historically, there was a rule of consistency. If you had a two-person conspiracy and one was acquitted, the other had to be too. Texas law mostly says no to that.
So even if my partner in crime gets found not guilty, I can still be convicted of conspiring with them.
Generally, yes, unless literally everyone involved has been acquitted or somehow cleared. The focus is on your individual culpability. Did you agree with intent? Did you or someone in the group commit an overt act? If you can be guilty even if others weren't convicted for whatever reason.
Wow.
Yeah.
Okay, and number three follows that logic, not a defense if they haven't been prosecuted or are immune.
Same principle. Their status doesn't shield you.
Number four is interesting, belonging to a class legally incapable of committing the object offense.
Yeah, this covers specific situations. Imagine a crime that only, say, a public official can commit directly, like a specific type of bribery. If you, a private citizen, conspire with that official to commit the bribery.
I can still be charged with conspiracy even though I couldn't commit the bribery myself.
Exactly. Your role in the agreement makes you liable for the conspiracy, even if you couldn't pull off the final act alone.
And finally, number five, just like attempt, it's not a defense that the crime was actually committed.
Right. The conspiracy is complete the moment you have the agreement and the overt act. Success doesn't erase the conspiracy charge. It just means there might be another charge for the completed crime, too.
So the takeaway on conspiracy is the agreement is key, the first step seals it, and it's very hard to get out of once those elements are met.
That sums it up well. It's designed to hit criminal planning early and hard.
And the punishment, subsection D, does it follow the attempt rule?
Mostly. It's generally one category lower than the most serious felony that was the object of the conspiracy. State jail felony conspiracies become Class A misdemeanors.
But there's an exclusion mentioned, section 76.02.
Yes, and that's important. The statute says this one category downgrade doesn't apply if the object felony falls under section 76.02.
What's 76.02 about?
That section deals with engaging in organized criminal activity, essentially, racketeering, and ongoing criminal enterprises.
So if you're conspiring as part of a larger criminal organization, the law doesn't give you that penalty break for just planning it.
Precisely. The legislature is saying that conspiracies linked to organized crime are inherently more serious and don't get the standard preparatory offense discount. The full weight applies.
Okay, we've done trying, attempt, and planning conspiracy. Now for the third type, asking. Criminal solicitation. This feels different again.
It is. This is about inducing someone else to commit a crime for you. Section 15.03 covers the standard high-level solicitation.
High level how?
The bar for the intended crime is incredibly high here. To be guilty under this section, you must have the intent that a capital felony or a felony of the first degree be committed.
So you're asking someone to commit murder, aggravated kidnapping, the absolute most serious offenses.
Exactly. The act itself is defined as requesting, commanding, or attempting to induce another person to actually engage in that very serious conduct.
Just asking is the crime.
Asking with the specific intent that they actually do it, yes. But because it's based purely on communication words exchanged, the law puts up a huge roadblock for conviction. That's subsection B, the corroboration requirement.
Okay, this sounds critical. What does it mean?
It means you cannot be convicted of solicitation based only on the testimony of the person you allegedly solicited. Their word alone is not enough.
So if Bob says Alice asked him to commit murder, Bob's testimony by itself won't cut it.
Correct. The prosecution needs strong corroboration, and it has to corroborate two things. First, that the solicitation, the asking, actually happened, and second, that the person asking, Alice in your example, truly intended for Bob to carry out the crime.
Why such a high bar? Seems higher than for conspiracy.
Because the potential for misunderstanding, exaggeration, or outright fabrication is much higher when the entire crime is based on proving what someone said and meant. Was it serious? Was it just boasting? Was it taken out of context? This requirement protects against wrongful convictions based on potentially unreliable testimony.
So the state needs something else, like a recording, a witness, maybe proof of payment for the solicited crime.
Exactly. Something independent that backs up the claim that the solicitation occurred and was meant seriously. Without it, the case fails.
Given that it targets asking someone to commit the worst crimes, what's the punishment? Subsection D?
It's severe, as you expect. If you solicit a capital felony, the solicitation itself is first-degree felony. If you solicit a first-degree felony, the solicitation is a second-degree felony.
So notice there's no automatic one-category drop like an attempt or conspiracy.
Right. For these highest-level solicitations, the law treats the act of asking as almost as serious as the intended crime itself. Trying to get someone else to commit murder is taken extremely seriously.
Okay, that's standard solicitation. But then there's section 15.031, criminal solicitation of a minor. How does this change things?
It broadens the scope significantly when the person you're trying to induce into crime is young. Here, the solicited person must be a minor, defined as younger than 17.
And the intended crime doesn't have to be capital or first degree anymore.
Correct. The list of potential underlying offenses becomes much longer. It includes things often associated with gang activity, serious drug offenses, human trafficking, sexual offenses, violent crimes. The statute references specific lists, showing the legislature's focus.
So the aim here is really to stop adults from pulling kids into serious criminal activity.
That's precisely the goal, protecting minors from being groomed or pressured into becoming involved in things like drug distribution, organized theft, or violence.
What about the punishment under this section? Does the one category drop apply here?
Generally, yes. Subsection E starts by saying it's typically one category lower than the solicited offense, but there's a huge exception.
Another one. What is it?
The punishment jumps back up to the same category as the solicited offense. No discount, if two conditions are met. First, the actor soliciting the minor must be 17 or older and be a member of a criminal street gang.
Okay, gang affiliation.
And second, they must have committed the solicitation with the intent to either further the gang's criminal activities or to help the gang avoid detection or apprehension.
So using a kid to do the gang's dirty work means you get hit with the full penalty, as if the kid had actually done the crime.
Essentially, yes. The gang status and motive completely remove any leniency. The law treats it as an extremely aggravated form of solicitation.
All right, and then there's a third, even more specific type, section 15.032, child grooming. This sounds newer.
It is, from 2023, and it's very narrowly focused. The intent here must be for the child to commit or be the victim of specific listed sexual offenses, things under chapters 43, 28, 21, or 22 of the Penal Code.
So this isn't about general crime. It's purely about sexual exploitation. And the age.
Here, the victim age is slightly broader, younger than 18.
And the act of grooming. How is that defined?
The language is quite descriptive. The actor must knowingly persuade, induce, entice, or coerce, or attempt to do so, with that specific sexual intent. It targets that deliberate psychological manipulation process.
Persuade, induce, entice, coerce. That covers a lot of ground.
It's meant to capture the predatory behavior of building trust, or using pressure specifically to lead towards a sexual offense.
What's the base penalty?
It starts as a felony of the third degree. But, again, there's an enhancement in subsection B.
Let me guess, prior offenses.
Exactly. If the actor has a previous conviction for certain serious sexual offenses involving a child victim under 18, this new grooming charge jumps up to a second-degree felony. Faster escalation for repeat offenders targeting children.
Okay, but this section also has something quite different, right? An affirmative defense in subsection C.
Yes, and this is really important for understanding the nuances. Remember, affirmative defense means the defendant has to prove it applies.
What does the defense allow?
It can apply only if the actor accused of grooming is also under 18, and the child they allegedly groomed is also under 18. But that's not enough. Two more crucial conditions must be met.
Which are?
First, the age difference between the actor and the victim cannot be more than 3 years. And second, they must have had a pre-existing dating relationship or have been legally married.
Ah, so this is the law trying to distinguish between predatory adults targeting kids and, well, teenagers dating each other.
Precisely. It's trying to avoid criminalizing normal, albeit possibly inappropriate, interactions or relationships between peers, especially where the age gap is small. Without this defense, you could imagine scenarios where typical teenage online flirting or relationship dynamics could technically fit the persuade, induced, entice language leading to felony charges between minors.
So it's a carve-out for close-in-age peer relationships, acknowledging that's different from an adult preying on a child.
Exactly. A necessary, if complex, legal distinction.
Okay, we've laid out these preparatory crimes. Attempt, conspiracy, solicitation, they seem pretty comprehensive. But what if someone starts down one of these paths and then genuinely changes their mind? Is there any way out, an escape hatch?
There is. It's called the renunciation defense, laid out in Section 15.04. It's designed specifically to encourage people to back away from committing crimes.
But you mentioned it's an affirmative defense, so the burden is on the defendant to prove they qualify.
That's right, and the standard is high. The renunciation has to be both voluntary and complete. You can't just get cold feet because you think you might get caught.
How does it work for the different crimes? Let's start with attempt, subsection A.
For attempt, the person has to show they voluntarily and completely renounced by essentially stopping their criminal conduct before the crime happens. Or, if just stopping wasn't enough, maybe things were already too far in motion, they had to take some further affirmative action that actually prevented the crime from occurring.
So just walking away might not be enough if you've already, say, lit the fuse.
Right. You might have to put the fuse out or call the fire department, take an active step to stop the harm you initiated.
And for conspiracy or solicitation, subsection B, where other people are involved.
The bar is even higher there, logically. You have to show you countermanded the solicitation, told the person you asked not to do it, or effectively withdrew from the conspiracy before the crime happened. And crucially, you must also show you took affirmative action that prevented the commission of the planned offense.
So you can't just stop answering calls from your co-conspirators. You have to actively try to stop the whole thing.
Exactly. You have a duty to undo the danger you helped create. Maybe warn the intended victim, alert the police, something concrete that thwarts the plan.
Now, the key part seems to be voluntary. Subsection C tells us when renunciation is not considered voluntary, right?
Yes, this is critical. It closes potential loopholes. Renunciation doesn't count. It's not voluntary if it was motivated by certain things.
Like what?
Number one, if it was motivated by circumstances that suddenly make getting caught seem more likely. The classic example is seeing a police car turn the corner just as you're about to break in. Stopping then isn't a change of heart. It's fear of imminent arrest.
The, oh, cops' defense doesn't work.
Basically, no. Or if you realize the safe is much tougher to crack than you thought, that's just abandoning because it got too hard, not because you decided crime is wrong.
Okay. What's the second invalid reason?
If your decision was just to postpone the crime, maybe wait for a better opportunity. Or if you decided to switch targets, rob a different bank, harm a different person.
So I'll do it next Tuesday instead. Doesn't count as renunciation.
Not at all. Because the underlying criminal intent is still there. You haven't abandoned the criminal objective, you've just rescheduled or redirected it. Renunciation has to be a complete abandonment of that specific criminal goal.
Makes sense. But what if you try to renounce, you make a real effort, but you fail? Maybe you call the police, but they don't get there in time, and your co-conspirators still commit the crime. Is there any benefit then?
Yes, there is, under subsection D. This is about mitigation at sentencing. Even if your renunciation didn't prevent the crime, so it's not a full defense to the conspiracy or solicitation charge, evidence that you made a substantial effort to prevent it is admissible during the punishment phase.
And what does that do?
If the jury or judge believes you made that substantial effort, your punishment shall be one grade lower than it otherwise would have been. So the law still rewards the genuine attempt to stop the crime, even if it ultimately failed.
So a partial credit for trying to do the right thing, even if too late.
A good way to put it.
Finally, Chapter 15 wraps up with Section 15.05, the no offense rule. This sounds like a rule about what isn't a crime.
It is. It's a simple but crucial rule to prevent legal absurdity.
Yeah.
It basically says you cannot commit an attempt, conspiracy, or solicitation of another preparatory offense defined in this chapter.
Meaning?
You can't be charged with attempted conspiracy or conspiracy to commit solicitation or attempted attempt. It prevents an infinite regress, right? It keeps the focus on the actual underlying felony that the state is trying to prevent, the murder, the robbery, the arson. These preparatory offense laws are tools to stop those crimes. This rule stops the tools from being turned back on themselves in a confusing loop. It keeps the legal framework grounded. #outro.
Okay, so this whole dive into Chapter 15 really paints a picture, doesn't it? It shows just how much legal thought goes into defining crime before the final act, before the real harm is done.
It really does. We've seen those three main paths: trying, planning, asking. Attempt, conspiracy, solicitation.
And that common thread through all of them, specific intent to commit an actual felony. That's the bedrock.
Absolutely. Coupled with different levels of action required. You need that substantial step, getting really close for attempt.
Right. But just an agreement plus any small overt act for conspiracy.
Yeah, a much lower bar there. And then for solicitation, it's the asking, but with that really high corroboration requirement for the most serious ones.
And we saw how the punishment often drops a level if you fail.
Unless you're targeting cops or soliciting as part of a gang or grooming a child after prior offenses, then the law shows its teeth, keeps the penalties high. It's a complex balance.
Trying to prevent harm, but also trying to respect that line between thinking and doing.
Which brings us to a final thought, maybe something for you to chew on. We talked about Section 15.05, how you can't attempt an attempt or conspire to conspire. It keeps the focus on the object felony.
Right.
But think about conspiracy again. That overt act can be minimal, just one step showing the plan is in motion. Now, consider crimes planned entirely online in encrypted chats, or maybe using AI to help plan or even execute parts of a crime.
Where the overt act might just be sending a message or running a piece of code, something instantaneous and virtual.
Exactly. When the step towards the crime doesn't involve physically moving towards a target, but happens purely in digital space, does the law's very low threshold for an overt act in conspiracy still make sense? Or does it risk criminalizing planning and communication too early before there's any real-world proximity to harm?
How does the legal system adapt to define that line between preparation and punishable action when the actions themselves are becoming less physical, more algorithmic, maybe harder to detect until it's too late?
That's the challenge, isn't it? How these principles of intent, agreement, and action apply in a world where crime itself is evolving. Something to think about.
Definitely something to think about. Thanks for joining us on this deep dive. We hope you found it useful. We'll see you next time.